Welcome to Dolly Talk. How is everybody doing today? We have a fun one here with our boy Carl, as known as Bubbles. He is on the stand right now, and we are going to start with cross-examination. Yes, we can see you, we can hear you. Phew. I was only 1 minute late, so that's not too bad. How are you, Paul? And Jim is here. All right, let's see. Figure this out. There's our boy, one of them.
Your Honor, I don't have any further questions.
Cross.
Yes, thank you, Your Honor. Good afternoon, Mr. Clouse. Let's start with the incident itself. We got a lot of ground to cover, but let's start with the incident itself. So you are in the kitchen and you have your knife out because Daniel's raised his voice, correct?
Daniel's screaming at me.
Okay, his voice is raised and you pull your knife out, correct?
Yes.
Okay.
Use
And
me
it's open,
while I
it's
whip it
You've
out.
seen the knife,
Yep.
and you have it in your hand, correct?
Down on my side.
You have it in your hand,
Yes.
correct?
Yes.
And Daniel comes into the kitchen, and your testimony is you trip over the 24-pack of water that's on the ground.
48.
You trip over the pack of water on the ground, and you fall backwards. And
He is so pedantic. You tripped over a 24-pack of water. It was 48, ma'am. Thank you.
Daniel's holding on to you, correct?
Yep.
And how is Daniel holding on to you as you fall?
Like this.
He's got both arms like this.
Yes.
And so where's the knife?
In my hand.
Pointed up?
Yep.
Okay. So you're falling backwards.
Yep.
Did Daniel push you or do you trip?
I trip. He's pushing me and I trip.
Okay, but he doesn't push you to the ground. You fall on the ground to the ground by yourself.
Correct.
Okay. But he's got a hold of your arms.
Sure.
And the knife blade is up.
Yep.
And then at what point did you let go of the knife?
As I'm falling.
As you're falling.
Yes.
So the knife is in the air? I mean, you fall.
It's in the air as it's falling.
Okay. You have a glove. I can use the judge's purple one.
You might have to grab one.
Can I have a glove, Your Honor?
Oh, sorry.
Oh, deputy, why don't you just use the condom that's been in your wallet since 1998? Come on, can they find a glove?
So this is the knife we're talking about, right?
That's the one.
Hi, Irish.
So blade is up, right?
Yes.
You're falling backwards. At what point do you drop? Where are you in your fall when you drop the knife?
I'm
Have you hit the ground yet?
laying backwards.
Have you hit the ground yet?
Not yet.
Okay, so you're mid-air,
Yes.
blade up and open.
Yes.
You drop the knife,
Yes.
and does it float in the air? It lands on your lap.
You're trying to be funny.
No, I literally do not
Yeah.
understand what you are describing. So I'm asking you to make it clear. You let go of the knife mid-air
Yes.
as you're falling.
Yes.
Are your hands above your head?
My hands are in front of me, just like this.
Okay.
Just like this.
So Daniel is also in front of you.
Yes.
How much space is between you and Daniel?
I'm not calculating. Daniel is in front of me, got a hold of my wrist, and pushing me backwards.
Are his wrists at your chest height?
I couldn't tell you. Don't know.
Okay, so where's the knife at
I'm
when
not
it
paying
falls?
that kind of attention. I don't know.
But you're saying the knife falls blade up onto your lap. Describe your lap. Is that your thigh? Is that your stomach?
I said I bet my belly. Not, I didn't say lap, I said it on my belly.
Blade lands and it just sits there perfectly upright.
It's not like a large period of time. It's going quick, fast.
Okay, so are Daniel's hands at your wrist or are they down where the knife ends up landing?
Well, the position we're in, we're like this, so
Whoa.
it's like this.
And the knife stays in an upright position
Sure, it's falling straight down.
and goes into Daniel's arm.
I assume I had to, yes.
But it doesn't go through Daniel's arm. It goes in a couple inches at a 45-degree angle.
Apparently,
While propped up on your stomach.
apparently.
Okay. And what happens then? After Daniel gets stuck, what happens?
We hit the ground, he pummels around on my belly, crawls over top of me into the laundry room and grabs my phone, crawls back out, gets up, and
So he crawls over top of you, and you said that's why there's blood
on the dryer,
in 3 different places,
on the
right?
dryer, on the floor.
So I believe you told Mr. Brenner
Irish.
that the blood on the floor, the blood on the washer, the
Dryer.
and the
Not a
blood
washer,
that's
you lying
here on
whore.
the corner
A dryer.
are all from Daniel trying to get your phone. Is that right?
The process,
All 3 of those.
yes.
But you don't get blood anywhere else on your upper body.
No. It's
But
his arm. If his arm's going away from me, why would I?
Is his arm not bleeding?
I didn't say it wasn't. That's why it's blood out in the floor.
But
Yeah,
none of
you're
it dripped
moving
onto your upper body.
Arm
He's
out,
going away from me.
clean the blood
He's going
out.
over top of you to the dryer to get your phone. That's
Yeah.
what you told your attorney.
Yeah, because,
Over top of you.
exactly, away from me.
What's the gap here?
Yeah, you're
Is,
cleaning
is,
the
is
blood
this
away.
gap enough for you to lay down?
Where's
My
Dexter?
upper portion of my body is the only thing that was in that laundry room. The upper
What is
portion
the
of my
gap?
body.
Sir, what is the gap? How wide
I
is
didn't
that?
measure it.
It's your house. How big is that?
I didn't measure it.
Okay.
Lord, this guy knows his dick size down to the
So-
millimeter, I bet.
Not only is Daniel bleeding all over your stomach, he's bleeding all over here, he's smearing blood here, and he smears blood here. Just to get your phone. Where was your phone? Point to where your phone was.
I'm on my back. I couldn't see where my phone was. I'm on my back.
Even with those glasses?
I have no idea where it was. All I know is it went over my head.
And you said your wife wasn't in the kitchen for any of this.
I said I did not see her.
You've heard her testimony that she was there.
I heard you mess her up real bad. That's all I heard. You messed her up real bad.
She's in fact told you many times that she was there, correct?
I heard her say that she's not sure of a lot of things.
And you in fact told her to be careful what she testified to, didn't you?
No, I did not.
Objection, Your Honor.
No, I did not.
So you didn't tell your wife that she ought to consider what she said before she said it to evaluate if it was going to hurt you.
No, I did not.
Your Honor, may we approach?
Yes.
Okay. So did he try to coach his wife? So something's out. Okay, something's happening at sidebar. Let's see. Looks like that was sustained.
Okay, so let's go back. Let's back up to when you pulled the knife.
Okay.
Daniel
So yeah, so much for that line of questioning.
was not near you when you pulled the knife.
He was in there by his bedroom door.
Okay. And you said that, and we heard Daniel say it's what, 30 feet? Right? About?
Here to that wall.
Okay,
Hey,
that's
Helen.
a pretty big distance.
Sure.
And you felt the need to pull the knife when he's 30 feet away from you.
And put it down by my side in case I needed it.
He had not threatened you, correct?
It was his choice to come to me.
He had not threatened you, correct?
His voice did. Yes, it did.
Daniel had not threatened you, correct?
No.
Daniel did not have a weapon, correct?
No.
And you pulled it in case you needed to defend yourself.
Correct.
And so you've testified that you have this PTSD from the prior incident with Daniel 10 years ago, correct?
Correct.
And you talked about how he broke your nose, broke your cheekbone, correct?
Yep.
Move,
And
game,
that's that
stay.
incident that I talked to Daniel about where he was found guilty of a disorderly conduct, correct?
He pleaded.
To a disorderly conduct,
did.
correct?
He did.
And you told Mr. Brenner you were arrested as a part of that as well, correct?
For that little red mark he had on his cheek.
So is it fair to say that was a mutual combat situation?
No, ma'am.
And then you talked about the incident where you put a loaded pistol to his chest, correct?
Yes, ma'am.
You said you don't remember that because of the PTSD.
Yes, ma'am.
What do you mean by that?
I mean, I blacked out during the incident.
African
But
American
you didn't
doubt.
black out during this incident,
No, ma'am.
but you don't remember your wife being in the kitchen.
She was not in the kitchen.
So you're saying she lied today?
That's why I had Mr. Brenner there ask her if she recalled being in the bathroom. And she said yes,
She said prior to.
at the start of it. She did not say prior to, she said at the start of it. Remember, she corrected herself.
So she lied when she said she saw the two of you arguing and she was in the kitchen there too.
We were not arguing.
Now you're being pedantic.
And you don't recall Danny throwing a pack of pop at
No,
you.
I do not.
Could you have blacked out for that part?
Anything's possible.
And you had approximately 24 ounces of bourbon.
No, ma'am.
You said that it's
A pint and a half.
What are you, my sponsor?
16 ounces.
I'm not sure exactly what it is, but it's not no 24 ounces.
Well, you do a pint and a half, if a pint 16 ounces, and you have another 8 ounces, that's 24, right?
I'm not sure what it is.
Okay, but you do half bourbon, half Coke in your,
And ice.
and ice.
Oh, maybe it is 24.
But you drink a pint and a half.
Over 18 hours.
Okay. And
Yeah, I mean, a pint and a half is technically 24 ounces. I mean, he's a machinist, though. He doesn't, and a drunk, he doesn't focus on how many ounces is in something. Australia is as fake as Salvador's libido. God damn it, David. Thank you for that. It's very generous, kind of.
so you were drunk.
No, I was not. I have a very high tolerance. It's not like I started drinking yesterday.
I'm a huge
And you
drunk,
don't like
man.
Daniel very much, do you?
Yes, he's my son. I love him, but I don't like him anymore.
And that's because you think he's no good. He's lazy, doesn't do anything, doesn't work for anything.
He has no respect. He stood and told me to my face while spewing spittle in my face that parents do not deserve respect. They've got to earn it, and I've never earned it.
And so you were irritated on the morning of August 2nd.
No,
You told Mr. Brenner you were irritated.
well, over the fact that he's not done anything for all that time. But I've come to be used to that with Daniel.
But Marlene told you that morning he'd already been out.
And if anybody hasn't seen that's his lovely son right there, and his lovely wife. Yeah. Pretty sure he's going to be claiming squatter rights on the chair soon.
No,
She
she
already
didn't.
did.
No, she didn't.
So she lied.
We didn't
when she
discuss
said
that. We didn't discuss that
She lied when she said she told you that this morning?
this morning.
This morning she testified. She told you he'd already been out of bed. You're saying she lied?
I didn't hear her say that.
Was that his fiance? Or his, I think that's his mother.
And
Yep.
then you got even more irritated when Danny said, I've got my 30 days in here, you've got to evict me. That pissed you off.
I'm used to that too.
That pissed
I've
me
heard that
off,
many
and I don't
times.
even know these people.
So what about this day was different than any of the other arguments you described having with Mr. Brunner? Do you pull a knife in every one of them?
No,
So what's different about this day?
because I felt like my safety was in jeopardy
Why?
because of Daniel has had that blow up with me many times. I know what he sounds like when he's getting ready to blow, when he's getting ready to
Oh.
attack.
How many times has he attacked you?
We had a situation here, she was in Kentucky, and
Of course
he
she was.
had his 2-year restraining order against me. And she had told him he could come to my house and pick up a air conditioner. And if it hadn't been for the fact that I refused to step up to him, he was going to beat my face in right in the middle of the street in front of my house, begging me to just flinch. And he was going to beat my face in right in the middle of the street in front of my house.
But he didn't.
No, he didn't.
Okay. So other than that time in 2015,
How many times does it take?
Who?
How many times should it be?
but I'm just saying, what made this time different? You said you don't always pull a knife. Why was this the time?
Because I felt intimidated. I felt threatened.
Because he was screaming.
It
at
doesn't matter.
Knows the buzzwords to say, but he doesn't know how to really.
But it's your testimony here today. You did not stab him.
No, I did not.
And in fact, you weren't even holding the knife when he got stabbed.
No, I was not.
Okay.
So it was an accident.
The whole point is, it would not have happened if he would have just stayed where he was at and not come at me. That's the whole point. If he would have just stayed where he was at, even his own statement, he said his mother got in between us. As I said, I don't even recall her being in the kitchen. But if his mother got in between us, and if he would have let that be a stopping point, if he would have took that as a opportunity to cease hostilities, not throw her out of the way, it could have stopped right there.
Do you recall talking to the police that day?
Sure.
And do you recall telling them that you did not know how you got the injuries on your arm?
No, I do not.
And do you recall telling them that Danny was punching you?
No, I do not.
So is it fair to say there's a lot you don't remember about that day?
Probably.
Connor here raises a very interesting point. I was probably going to mention it later because they do discuss it. They're at this point, they aren't even sure if they're going to get a self-defense instruction. And as Connor says, he can't claim self-defense if he says he wasn't holding the knife when his son got stabbed. You know, typically you claim self-defense because I did the act. The reason I did the act is because I was afraid. I guess you could kind of get into a gray area of brandishing but he's kind of going for imperfect self-defense here. So we'll find out more about what the judge wants to, how the judge will handle it. But yeah, that's a very good point.
And do you recall, Danny came at you, this is your position, Danny came at you to take the knife away from you.
Yes,
Not to attack you, to disarm you.
whatever.
Well, no, that's not whatever, sir. There's a big difference between attacking and disarming. That's how she ended. That was a pretty good ending.
Just very briefly, Your Honor.
I mean, I'm team
And so,
Carl with it.
just to clarify, so you did not see Marlene in the kitchen?
In the kitchen? No, I did not.
Okay. Do you have any idea where she was?
No, because I thought she was in the living
Yeah.
room,
Okay,
and I did not look.
sure. And so you pulled the knife out, you're holding it in your right or left hand?
My right hand down to my side, and it was facing away from Daniel.
Okay. And approximately are you watching Daniel as he approaches you?
No, I did not look at him at all. When I heard him say, "You pulled the fucking knife on me," and when he said it the second time, I still didn't look at him. I just turned and picked up my phone.
Okay. And then, approximately, and is it like immediate like that? And he's on you, or how, is there a time break or?
I'm going to say 30 seconds, even if it was that, because I'm trying to turn on my phone, I'm thinking, oh, you better look. And when I looked up, he's there.
Okay, so it's pretty quick.
Yeah, pretty quick.
All right. No further questions, Your Honor.
Nothing.
All right, ladies and gentlemen, if you have any questions for Mr. Clouse, please reduce them to writing. Do not discuss or display any proposed question with other members of the jury.
Prosecutor did a pretty good job on Cross there. He definitely should not have testified. I think his chances of being convicted are much higher now. I thought he was credible, but his story isn't really great with the jury instructions aren't really going to help him. I don't know. I kind of liked him though. Or maybe I just really dislike the son, one or the other. So we're waiting for questions now.
All right, Mr. Clouse, the members of the jury have a few questions which I will read and you will answer, and then the attorneys may have some questions for you. Okay, sir? Why were you grabbing the phone?
I was going to try and call the sheriff real quick myself.
Why did Daniel have a restraining order against you?
There was the restraining order. Are we talking about when I was talking about the air conditioner? I'm coming to get the air conditioner?
Well, that's
Okay, what the restraining order against me was, he had gotten a restraining order to get me out of my house, keep me out of my house. So he was going to take over my house. He had claimed that I threatened to shoot him in the face with my AR-15, which was a lie. It didn't happen. And I did get arrested for that.
Okay, easy Rittenhouse.
I think my attorney has the information on that. When they arrested me, confiscated my AR-15, they found that the bolt wasn't even in with the rifle. The gun could not be fired because the bolt and firing pin was not even with the rifle. It was a pile of useless metal. It was another lie that he told to have myself but arrested. While I was in jail, he got a 2-year restraining order against me so he could keep me out of my house. I slept in my car for 4 months till I got an attorney and got it turned around on him, and he got out of my house. He let me go back home. That's why he had a restraining order on me.
Why would you welcome Daniel into your house with what has happened in the past?
Very good
Because
question.
he keeps calling Mama and saying, Mama, Mama, I'm in dire straits. She's had 2 strokes. He knows he can get her upset to the point to where I finally say, okay, calm down, baby. He can come back. Otherwise, stress is what caused her strokes. He knows he can get her to the point to where she's so upset, I don't want her to have another stroke, and I'll say, okay, baby, calm down. Tell him he can come back. That's why.
Did you at any time point or raise the knife in a stabbing position?
No, I did not. No, I did not.
All right. Any questions based on the jury's questions, Mr. Brenner?
Just very briefly, and Mr. Clouse, just to clarify, so that protection order that the jury asked you about, that you referred to,
Yes.
right, is that out of that same 2020 incident that we talked about?
2020, it was, oh no, the 2020 was the pistol that
Okay.
you were talking about. No, this is a separate incident. And actually, let me get a little further with that.
Oh, boy.
AR-15, that was the
I
AR-15.
don't think we need to get too far into it. I just want to make sure that we're clarifying the protection order because that's what was asked about, right? So when was that protection order put in place?
That was 23.
23. Okay.
And I was the one actually called the sheriff that time because I can't even call it my daughter-in-law because he refused after 20 years, even after 20 years, he refused to marry her. That was my granddaughter's mother. He refused to marry her for 20 years. But I called the sheriff's department because she hit me.
Sir, that was his baby mama.
And while the sheriff's department's on their way, she calls him and tells him what's going on. So while he's on his way home, he calls the sheriff's department and tells them I threatened to shoot him in the face with my AR-15. Now, when they get there and they go confiscate my weapon, they find the bolt is not even with the weapon. It can't be fired. The bolt's on the kitchen counter at my house. So when I come home from jail, they find that the bolt's gone. Where did the bolt go? While I was in jail, he took it and sold it. There you go.
So that's why the protection order was in place.
That's right, why I had a protection order.
No further questions, Sharon.
Ms.
Bob's your
Nicholson?
uncle.
How many protection orders has Daniel had against you?
That's the only one that I know of that wasn't court ordered.
Well, that wasn't my question. How many protection orders has Daniel had against you?
3.
No
That I know
further
of.
questions.
I know of.
All right, ladies and gentlemen, at this time, I'm going to need to take another break for 15 minutes. It's about 3:15, so we'll come back at about 3:30 and figure out where we're going.
I think we need a poll.
Nothing
Okay, so
from
we're
our,
going to come back. We need to talk about some things, so just remember my instructions. Don't discuss the case with anyone or allow anyone to discuss it with you in your presence. Do not form any opinions about the case yet. All right, thank you.
Well, Scott, why would you live in a house that you had 3 protection orders over? Well, he was in dire straits. Mama, help me.
You can step back. You can step back.
That's a
Come
good
on over
point,
here.
Irish.
All right, and Mr. Brenner, you don't have any exhibits, correct?
no, Your Honor, I think we used the same pictures, so that's all that we would have.
Ms. Nicholson, are you calling any rebuttal?
Yes, Your Honor, one witness.
Who is it?
Deputy Charlie Hale.
Okay, so we are not going to finish today.
No, we'll finish Deputy Hale, but I don't expect, I think it would be 4 o'clock. I mean, with the little break, I think it would probably be 4 o'clock before we even
That's
thought about
Mom.
getting to closing.
Danny
Or
Boy
later.
is there.
You guys can't do 5-minute closings?
I mean, I don't know that it's that lengthy, but, I mean, if the court wants to push on, I'm fine, I'm happy to push on. Doesn't matter to me.
I hate to be annoying. I like to, if I can, have the night. Obviously, we're up to the court. If the court wants us to proceed, I'm happy to proceed, but I always like
Thank you, Mr. Brenner, I appreciate that.
I always like to have more time to look at everything for close if possible.
Your Honor, at some point, the state would like to be heard on the issue of the self-defense instruction.
Let's do it now.
I do not believe the defendant is entitled to it. He is making, it's a justification defense. I was justified in my action for fear of my safety. The defendant here is not admitting to an action. Brandishing a knife is not a self-defense action for felonious assault. And he denies, he in fact says it was accidental, the stabbing. And so he denies causing serious physical harm. He denies attempting to cause or causing physical harm with a deadly weapon. So you cannot deny the charge and say you acted in self-defense, and brandishing is not an action in self-defense.
I don't know that I agree with that statement in general, because I think sometimes in self-defense you can brandish a weapon in self-defense. I don't know that I agree with that premise. But let's hear from Mr. Brenner.
Well, Your Honor, I think, one of the, A2 of felonious assault is cause or attempt to cause physical harm by means of a deadly weapon or dangerous ordinance. I think here, what Mr. Clouse has testified to is that he had a weapon, a knife in his hand while engaged in a struggle. And I think that it could at least be construed as attempt to cause physical harm to another, even if he's denying actually actively stabbing someone. I mean, he was holding a knife while engaged in an altercation. And I think, the testimony is pretty clear that he pulled the knife, he brandished the knife, and then he had the knife in his hands while struggling with his son. I think that under the most generous reading, I think at least that could be construed as attempting to cause physical harm.
Pointing a knife at someone is not attempting to cause physical harm. And in fact, I believe Mr. Clouse's testimony was he pulled it in case he needed to use it.
Yeah, it wasn't brandishing.
He claims he did not use it.
He didn't want his son to see it.
I've looked at a lot of case law, and it overwhelmingly is you cannot generally have accident and self-defense. They are inconsistent with each other. So I mean, again, brandishing a knife at someone does not alone is not sufficient for a charge of felonious assault. We could not sustain a conviction of felonious assault for alleging that Mr. Clouse brandished a knife.
Yeah. Well, I would say, again, I think the state made the decision to indict on the A2 subsection. And I mean, I think, again, he's holding a knife. They're engaged in an altercation. His testimony is that he was prevented from using the knife because his wrists were being held. But I still think that can get to attempt to cause physical harm. I think, Ms. Nicholson's argument holds a little more weight on the A1. But I think on the A2, it specifically says cause or attempt to cause physical harm.
I think along with, he was restricted from using it because his arms were held. Mr. Clouse is adamant he never stabbed, was never going to stab, in fact denies an argument or altercation. He says his son took him to the ground and he somehow in that process got stuck when the knife wasn't even in his hand.
So we have, since opening statements, probably even since voir dire, have
Definitely.
been telling this jury that they're going to.
I picked up immediately when I listened to voir dire when this went on. Didn't play it because it was like 2 hours, kind of tedious, maybe 90 minutes. But the prosecutor throughout it asked repeatedly, if you were instructed on self-defense, and they just kept talking about self-defense and if this is the scenario. So they've set up the jury to basically kind of expect self-defense instruction.
Hear the instruction of law on self-defense. Correct?
Yes.
Now we're in a situation that the state's asking to remove that instruction,
All the time.
leaving the jury to wonder why the court is not going to instruct on self-defense. After hearing all this testimony and all these arguments about it, and then I'm left with the state arguing that he pulled a knife, right? He's having a verbal argument and he pulls a knife. So now you're going to be arguing that in your closing, and then and then you're arguing then I can't give a jury instruction on self-defense. I guess at this point in time, I'm not going to rule right now. I'm going to think about it. But I guess my thought is I feel like there's less harm in going ahead and giving the instruction and letting the jury sort it out, with you making that argument that it's not self-defense, at least giving them the instruction for them to have since they've had it from the beginning. I guess that's where I'm at right now. Now, I'm not suggesting that I won't change my mind overnight, but it just seems to me it's less harmful to go ahead and give the instruction. They could decide, and you could argue, this isn't self-defense because he said that it's not self-defense, that he didn't use it in defending himself. I mean, I think that's the safer way to do it. That's just do you understand what I'm saying?
And I certainly understand that. I think knowing that a notice of self-defense was filed, it had the topic had to be voir dire.
Yeah.
But I think
otherwise, I agree with what you're saying, but then I'm kind of opening a door that I really just feel like they're left to wonder what happened to this law that the judge was going to give us on self-defense. They're left wondering about that, and then leaves a door open for you to argue that, hey, he brought a knife to an argument, or the old brought a gun to a knife fight, that type of thing. And I think it's just safer just to leave it in and let the jury sort it out. That would be my thoughts. But I'm going to think about it. Marcus and I will talk a little bit after court.
Oh,
Okay.
Marcus.
Thank you.
Okay, you need a break? You're good. Okay, you need a break.
I'll take a quick one.
Yeah,
All right, let's take a quick one.
Okay, so we just have a little bit more. I forgot there's like one more witness. So
The truth, the whole truth, and nothing but the truth, so help you out. I do. Proceed.
they're calling a detective back to rebut something that
Fresh
defendant
water
said.
if you need it, and that's touchscreen.
Go ahead.
Oh God, he's a
Thank
mouth
you, Your
breather.
Honor. Good afternoon. Could you please tell us your name, spelling your last name for the record?
Yeah,
Next,
Charles
please.
Sale, H-A-L-E,
And where are you currently employed?
Warren County Sheriff's Office.
In what capacity?
Currently assigned to road patrol in South Lebanon.
And were you so employed on duty and in a marked cruiser back on August 2nd of this year?
Yes.
And did you have occasion to respond to Lot 74 at the Shadow Lake Trailer Park in response to a domestic dispute?
Yes, I did.
And what was your job on scene?
When I arrived on scene, Deputy Carter had detained the defendant, and I spoke with him in reference to what had happened.
Okay. And do you wear a body-worn camera as a part of your uniform?
Yes.
And where do you typically wear it?
Right here in the middle of my chest.
You see the mount there. And was that operational on August 2nd?
Yes, it was.
And did it record your conversation with the defendant?
Yes.
Has anyone
And
ever
is
built a kangaroo?
is this your body cam right here?
Yes.
Thank you,
Is that a
EDW.
fair and accurate recollection or
Yeah.
representation of what occurred that day?
It is.
Your Honor, permission to play a portion of State's Exhibit 22 at this time.
Okay.
I gotta get to the right time. So just before I press play, will you orient us? What are we, where are we, what are we looking at?
We are in front of the defendant's trailer at Shadow Lake.
And is the defendant this individual here on the left of the screen?
Yes, it is.
For the record, I'm playing it starting from 1310.
All right. Do you want to give us your version of what took place here today?
Yeah.
All right. What happened?
I was out here working on my car. I went in the house. I was complaining about my son. He doesn't even live here.
Okay.
And my 43-year-old son, and he heard me complaining about him, came out of the bedroom, ranting and raving, and what have you. I've had a history with him.
Okay.
You see my nose?
Yep.
It's broke. It's been broke a couple times. Oh, him, he broke. And, Brandon Raven coming in here, and he's same history. And I knew he was going to attack me. And same thing, coming in here, raving. He's going to attack me. I knew he was going to attack me.
Like he told you he was going to, or you
No,
knew he was going
just
to?
history. I know what he's going to do.
Okay.
And came in, and he did. He was coming in to attack me again.
When you say he was coming in to attack you, what was he doing?
He didn't say he was going to attack me,
Right.
but raising his voice.
Okay.
He's for the last several years, he's wanted to take over daddy role.
We'll put it on in a minute.
Okay.
He wants to take over daddy role. He's daddy of the house now.
Okay.
He and raising his voice at me, yelling, screaming at me. So yes, to protect myself, I pulled my knife out, telling him, back off.
Is it the Swiss Army knife we took off of you, or a different knife?
No, I have in this case.
So not the knife I took off you.
No.
Okay. All right. Where's that? Where is that knife at?
He took it away from me.
He's got it. Okay.
Yes, he took it away from me.
That's my lucky stabbing knife.
I pulled the knife out. Did I attack him? No, I did not. You can look in there and the laundry room.
Okay.
He came all the way into the laundry room and took me down.
So well, hold on. When you say he took you down, what did he do?
When
You got to be specific here. Like when you say he took me down.
He physically came and tackled me.
Okay.
And when he tackled me, that's when he got stuck. He got stuck while he was taking me down.
So did you purposefully?
No, I did not purposely attack him.
Okay.
He tackled me.
So you're saying when he tackled you, that's when the knife
That's
cut
when
him?
he got That's when he got stuck.
Okay. And then what happened to you? Was that when you fell, or?
I don't even know how.
Correct me if I'm wrong, Louise and Scott, but it sounded like the father went on a bender on Fridays after he gets off work, but he doesn't drink too much throughout the week, was my understanding. He has a very high tolerance and drinks a ton. He was plastered that day, but it was kind of like just one of those things where he gets off work and then just stays up all night drinking.
I don't even know how I got my stuff.
Okay.
I don't even know how. But while he was tackling me, he got stuck. No, sir. That's my son. I love him. Even with this has been many cases.
Yeah.
You can check Middletown's records. he beat my face in Middletown, and I didn't press charges.
So he tackled you. We got that. Did he ever punch you? Or hit you in any way, shape, or
Yes,
form?
yes,
I know you say he tackled you, but I'm saying, like, did he strike you?
yes, while he was taking me down.
Okay. So how did he strike you? With a closed fist, open hand?
He was punching me as he was taking me down.
Okay. Okay. And that's all that happened?
Yeah, we didn't have time for anything else.
Okay.
But that was twice.
How much y'all been drinking today? Because I can smell it.
I've had a couple drinks.
Okay. What's a couple to you?
Me, I've had 2 18-ounce glasses.
2 18 beer?
No, I drink
Liquor?
liquor.
2 of these cups.
Okay.
But I'm in my own home.
Yeah, you're good. These are just standard questions we
I'm
ask.
in my own home.
What kind of liquor was it?
Evan Williams.
Evan Williams? Was that like a vodka?
Erwin Williams.
It's Kentucky. It's Kentucky whiskey.
Whiskey? Oh, okay.
But I'm in my own home. I should be able to.
Yeah, you can drink whatever you want to in your own home. These are just questions that we ask, man. Because obviously, has he been drinking? Has he been drinking?
No, but I do think he takes drugs.
Okay.
He has been for a long time.
All right.
But now, I have. He's not. Let me tell you this. He's had. It's just expired. But he's had a 2-year no contact order on me. That's just expired. He has. And it was for this home right here. He tried to have me put out of my own fucking home.
Okay.
You know, and I was gracious to let him come back here because his fucking girlfriend has been screwing him over, making him sleep in a fucking car.
Yeah, that ain't good.
No. I mean, and then he wants to come and attack me because I got something to say.
Aw.
This is ridiculous. This is fucking ridiculous. As I said,
Well, we'll get it all. We'll get it all figured out.
his blood's on me because he came back there to the damn laundry room and attacked me.
These guys are going to just check your arm real fast, okay? Just to make sure everything's good.
Buddy.
Just gonna give it a look.
It's just a scratch.
Can you stand up for me? Make it a little bit easier to look at it. That's good right there.
This is ridiculous.
Well, man, like I said, we got to do our job too.
So is that a fair and accurate depiction of your interaction with the
Wait, is that the town's main water supply or water tower? Huh. And thank you so much for the super sticker 2.0. I hope you're doing well. Yeah, I think there's probably drink that water, you're gonna get lockjaw. That's for sure.
defendant?
Yes.
And the angle's not real great, but we can see parts of a large blood stain on his shirt.
Correct.
You observed that.
Not to be vulgar, but I don't know, maybe I'm wrong, but I don't think mom is wearing a bra.
That day.
Yes.
And paramedics came and treated his injuries, correct?
Correct.
Did he complain of any other injuries to you?
Not at the scene, no.
Did he at the jail?
No.
Never complained, he never asked to go to the hospital?
No.
Never complained of any back injuries, head injuries, anything like that?
Not that I recall, no.
And you indicated at one point you could smell an odor of alcohol.
Yes.
Can you tell the jury a little bit more about that?
Yeah, it's coming from his person, coming from his breath as he would speak to me, because obviously we were in close proximity to each other.
Strong odor, light odor?
Strong odor.
I have no further questions.
Cross.
Thank you, Aaron. So Deputy Hale, you, fair to say you had a good amount of interaction with Mr. Clouse that day?
Yes.
And, I know we can only see it a couple different times, but my recollection of the video is that he has a pretty large blood stain like down around here on the shirt.
Correct.
Is that your recollection too?
Yes.
And I mean, from what I can see on the video, maybe that's a drop right above kind of his left, right around his collarbone there. But it doesn't look like, I mean, I don't see any other blood anywhere on the shirt. Is that your recollection as well?
Correct.
Okay. And you had said that it was a strong odor of alcohol.
Yes.
How would you delineate that? Like, what's the difference between a strong odor and a light odor for you?
Blood odor, I would say you would just occasionally get a whiff of. His was I was consistently getting a whiff of as he continued to speak to me and as I stood next to him.
Okay. And was he, I mean, seems that he was able to respond to your questions?
He was.
Okay. You ever had any interactions with Mr. Clouse previously?
I have not.
Okay. So that day was the first time you met him, first time you interacted with him?
Correct.
Your Honor, I don't have any further questions.
Redirect.
Nothing further.
Ladies and gentlemen, if you have any questions for Deputy Hale, please reduce them to writing. Do not discuss or display any proposed question with other members of the jury. At this time, it is 10 till 4. And you
Okay, we're going to get to closing. Maybe.
$2025.
Thank you. Please be seated. Good morning, ladies and gentlemen. Thank you all for being here promptly. Everyone was able to follow my instructions overnight, correct? Great. Now, if you remember yesterday when we left off, we had heard all of the testimony and the presentation of evidence. We're now going to move into the closing arguments of counsel. Ms. Nicholson, you have the floor.
Thank you, Your Honor. Ladies and gentlemen, you've now heard all of the evidence in this case. I want to take some time to talk with you about what the evidence shows and how that evidence fits into the instructions of law you're going to receive shortly from Judge Cheat. This case comes down to the testimony of three people: Daniel Clouse, his mother Marlene, and the defendant, his father Carl Clouse. They are the only ones present during this incident, and therefore the only ones that can tell us what happened. There was an incident on August 2nd, 2025 at 2479 Mason Montgomery Road, Lot 74, Warren County, Ohio, between the defendant and his son Daniel. Everyone agrees on that. Daniel ended up with a knife in his arm, received stitches, and follow-up treatment at Christ Hospital. It's not disputed either. So let's look at what the evidence told us about what happened to take this from a verbal argument to a stabbing. We hear there are two arguments. A brief argument that occurs in the living room. Daniel retreats back to his bedroom. Carl goes back outside. And then a second argument that occurs in the kitchen. Daniel hears screaming. He comes out of his bedroom, sees his father with a knife out. He moves his mom. He comes into the kitchen, moves his mom out of the way. Now, Marlene told you that her back was to Carl. So she didn't see that a knife was out, but she corroborated what Daniel told you. Daniel says he's got a knife, and he moves Marlene. Daniel then tells you what happens to lead up to him getting stabbed in the arm. The defendant refuses to drop the knife and refuses to respect the space that Daniel is trying to make. He tries to separate with the fridge door. Defendant doesn't care. He throws a pack of pop at him. Defendant doesn't care. He stabs Daniel in the arm. That doesn't stop the defendant either. Not until Daniel pushes him all the way back into the laundry room, has him on the floor, is holding his arm down and has a hand at his neck, does the defendant drop the knife? And then what does Daniel tell you he does? He leaves the laundry room. He goes and sits on the front steps, which is where the sheriff's office found him when they arrived after 911 was called. So now that we know what the evidence was and what the evidence showed, let's talk about the instructions of law and how the evidence shows the state has met its burden. Count 1 is felonious assault. That on or about August 2nd in Warren County, the defendant knowingly caused serious physical harm to Daniel. A person acts knowingly, regardless of purpose, when the person is aware that their conduct will probably cause a certain result or be of a certain nature. You are never going to hear Judge Teep tell you the state must prove the defendant acted intentionally with a purpose to harm his son. That's not what we need to prove, that he acted knowingly. He has knowledge of circumstances when the person is aware that such circumstances will probably exist. When you pull a knife out, and you've got a knife out in the midst of an argument or physical altercation, you have an awareness that someone could get cut. Court's going to tell you about causation. It's an act or a failure to act that in a natural, continuous sequence directly produces the physical harm to a person, and without which it would not have occurred. If there was no knife brought to this argument, no one would have been stabbed. But the defendant is not, his responsibility is not limited to the immediate or most obvious result. He is responsible for the natural and foreseeable consequences and or results that follow in the ordinary course of events. You bring a knife, you are responsible for what happens with it.
That's not a knife.
Now you're going to hear there are a number of ways in the state of Ohio that harm can fall into the category of serious physical harm. Serious physical harm is applicable to count 1. Physical harm is applicable to count 2. So the court's going to give you a number of these. I want to come back and talk to about these after you've heard the definition of physical harm. So on to count 2. It's going to be very similar. That on August 2nd in Warren County, the defendant knowingly caused or attempted to cause physical harm by means of a deadly weapon. The difference between count 1 and count 2, count 1 is serious physical harm, count 2 is physical harm by means of a deadly weapon. So what's a deadly weapon? Any instrument, device, or thing capable of inflicting death and designed or specifically adapted for use as a weapon or possessed, carried, or used as a weapon. You saw the knife yesterday. That's a deadly weapon. I don't think that's really in dispute. So then we have physical harm. Any injury, illness, or other physiological impairment, regardless of its gravity or duration. Daniel Clouse was stabbed with a knife. He required transport to the hospital. He required stitches. He required follow-up treatment and antibiotics due to an infection. There was a period of time that he told you it was extremely swollen, hot to the touch, and he had limited mobility.
Turgid.
He told you that he was in pain at an 8 out of 10 between when he was at Atrium and when he went to Christ. And he still has a scar. Ladies and gentlemen, I submit to you that he has suffered both physical harm and serious physical harm. Count 3, domestic violence, is identical to count 2, just without the deadly weapon. That he caused or attempted to cause physical harm to a family or household member. There is going to be an additional finding on count 1 of count 3. To do that, we must prove one of the following. It is or. It is not and. We do not have to prove all 5 of these. We have to prove one of the 5 of these. And while you must be unanimous in your decision that the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, you do not have to be unanimous on which one of these the state has proven. Just that collectively you agree the state has proven beyond a reasonable doubt any one of these, and therefore the defendant did not act in self-defense. The defendant was at fault in creating the situation, giving rise to the use of deadly force. He is at fault if he was the initial aggressor, and Daniel did not escalate the situation by being the first to use or attempt to use deadly force, or the defendant provoked Daniel into using force. The defendant brought the deadly force. The defendant did not have reasonable grounds to believe that he was in imminent or immediate danger of death or great bodily harm. And the defendant did not have an honest belief, even if mistaken, that he was in imminent or immediate danger of death or great bodily harm. And in deciding this, you must put yourself in the position of the defendant with his characteristics, his knowledge, lack of knowledge, and under the circumstances and conditions that surrounded him at the time on August 2nd, 2025. And you must consider the conduct of Daniel and decide whether his acts and words on August 2nd of 2025 caused this defendant to be reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. And the defendant used unreasonable force. A person is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger. If you find the state proved beyond a reasonable doubt that the defendant used more force than reasonably necessary, and that the force was greatly disproportionate to the apparent danger, then the state has proven that the defendant did not act in self-defense. Ladies and gentlemen, I submit to you, based on the evidence you heard throughout the course of this trial, and when using the test for truthfulness that you use in your everyday lives to assess the credibility of the witnesses you heard throughout the trial, and you consider everything, the state has proven the elements of felonious assault and domestic violence to you, beyond a reasonable doubt. And the state has proven that the defendant was not acting in self-defense for at least these three reasons, beyond a reasonable doubt. And therefore, I ask that you return a verdict of guilty.
Thank you, Mr. Nicholson. Mr. Brenner?
Thank you, Your Honor.
Ladies and gentlemen, very good morning. Thank you for being here. And I want to draw your attention back to opening, right? I said, I asked you to pay attention to the details, right? And I'm asking the same here. Okay, what we have here, I think what the evidence is borne out, is we have a father and son with a long and contentious history over the same kind of issues that a lot of people argue about, right? Money, work, family, right? And this argument, which sounds like it's the latest in a long series going back a decade or more, escalated to the point where it got out of control. I think that's clear. But it is the state's burden to prove, beyond a reasonable doubt, as Ms. Nicholson just outlined, each and every element of each of these offenses, right? It's the responsibility of the police to investigate crimes and for the prosecutor to prove it here in court. They must prove that he knowingly caused serious physical harm. So the state wants it both ways, right? They want to use Marlene's testimony to back up what Daniel was saying, right? But they also want to ignore the fact that Marlene herself testified that she has problems with her memory. She testified that Daniel was the initial one that made contact, right? So they want to use the fact that Marlene testified that she's in the kitchen, but they want to ignore the fact that she also testified that Daniel made initial contact, right? Even without Marlene's testimony about Daniel making initial contact, Daniel threw the case of pop under his own admission, right? That's the first physical contact, is throwing the case of pop. Okay, now Daniel's testimony, right? Daniel wants you to believe, hey, I just wanted to separate him and I wanted to get out of there, right? There's a door right behind him, the front door, right? He walked right past, right? So the layout of the trailer, if you'll recall, his bedroom's all the way at the end of the hall. There's a bathroom. He said that the front door is 2 steps past the bathroom, then the living room, then the kitchen, right? His testimony is that he comes from the back, his mom's in the kitchen, dad's behind his mom, right? If he is trying to separate them and he's trying to go outside, the front door is right there. He doesn't have to even approach his dad, right? Under his own logic, his own telling of the tale, right? It doesn't make sense. Now, I have no doubt that Ms. Nicholson's about to get up here and talk about all the reasons that Mr. Clouse has to lie, right? All the incentive that he would have to make this up. The fact remains, Daniel has all those exact same incentives to make up a story. In fact, he even has more, right? He's living with his parents, right, on the goodwill of his parents. He's not contributing. We heard quite a bit of testimony about that. That's what this argument's all about, right? He's not paying rent. He's not paying household bills. They got into over $100 worth of groceries, right? If Daniel is the one that's charged out of this situation, he's homeless. He's not just charged with a crime. He doesn't have a place to live. I would put it to you that that is a significant incentive to make sure that you are not the one charged out of the latest argument between you and your father. Right? I want to go back to Marlene's testimony. Right? Not only did she say that Daniel was the one that initiated contact, she said she never saw the knife, never saw it at any point. Daniel said he handed her the knife after the fight. Right? That's Daniel's testimony. End of fight, I got the knife, I handed it to my mom, I went outside. When the police respond, that knife is outside with Daniel. It's not with Marlene, right? Again, look at the details. And I have no doubt that Miss Nicholson is about to scoff at Carl's recitation of the events, right? She kind of did during her cross-examination, right, over the idea that one could fall onto a knife, right? But let's look at the physical evidence, look at the pictures of the scene that you're going to have available to you. What you're going to see in that laundry room is a pool of blood where if you fall on top of someone who's on the ground, Daniel's left hand would be, and then you have a smear of blood on the dryer where his right hand would be if he's reaching over his dad to reach something. And you might ask, if he got stabbed in the left arm and he had a hold of both of Carl's wrists, why did he have blood on his right hand? The answer is they fell on top of each other. You heard from Carl's testimony. And he was fooling around looking for the knife down around Carl's belly where all the blood was located on his shirt. He got blood on both of his hands, consistent with Carl's testimony, right? There's a smear on the freezer where he helped himself up. You know where there's not any blood? The top half of Mr. Clouse's shirt. So Daniel.
Welcome, Cat Raiders. How are you guys doing? Thank you for the redirect. We are currently watching a interesting domestic, well, more than a squabble, domestic violence type scenario where a 65-year-old man claims he was defending himself against his 43-year-old son, who's living at home with him. The son is a bit of a bum, a moocher. And the son gets enraged that the father grabs a knife. Father claims in self-defense because the son was yelling at him. Felonious assault. It's the ultimate white trash domestic of Pop versus Son. It's these are a fine example of human beings. Father was drunk. Yep. Yeah, he has a little drinking problem.
He wants us to believe, right, that he's
This is
holding
closing.
the fridge door, as some kind of a shield in his effort to get out of the door. And his dad is coming at him with an overhand stab and got him in the wrist. And at this point, they grapple. He has hold of both wrists, pushes him backwards. They go to the ground, right? If that is in fact what took place, we saw the blood in the trailer. There would have been blood all over the top half of Carl's shirt, right? If he has a bleeding wound as they go to the ground together, right, there would have been blood all over him, smeared all over. Instead, right, what we have is a large pool of blood right here, maybe a drop here. I don't know if that's blood or not, or if it's just a little hole or something that we saw in the video, but there's no blood up here. right? It's nothing consistent with blood spraying around or, scrambling and struggling, right? There's none of that. And again, I just want to stress, look at the evidence that we have available to us that can be verified via the pictures. In the States, she's going to talk about the fact that the knife in free fall is Mr. Clouse testified to, right? 2 items. It's a fundamental, it's 8th grade physics, right? 2 items, regardless of their weight, due to the force of gravity, fall at the same rate. This knife is not going to magically be floating in the sky, right? If 2 individuals who are like this, arm length apart, fall backwards, and the knife is dropped, it's going to fall at the same rate as those 2 individuals. And if the knife falls in between them, guess who lands on top of it? Right, it lands on an odd angle, sticks in his arm, right, causes that nasty wound that we saw, right, and also causes, most significantly, a pool of blood right around the lower half of Carl Clouse's body, which would be consistent with 2 individuals falling backwards at about arm lengths apart. And again, I just want to stress to look at the pictures, look at where the blood is, right? It's on the top half or it's on the bottom half of Carl Clouse's shirt. There's nothing on the top half, right? That all the deputies testified to that. You saw yourself in the video, right? And again, I want to stress that there's a smear on the dryer consistent with what would have been Danny's right hand, right? Again, the state has the burden of proving the elements of this offense and that it was not self-defense. Right? Ask yourself what makes sense, right? What is consistent? Reasonable doubt, right? Now, again, I think Marlene's testimony, by her own admission, is a little jumbled. She has some problems with her memory, right? There's things that don't really line up one way or the other, right? She says Danny initiated contact. She says she was in the kitchen. Carl says she wasn't in the kitchen, right? She didn't ever see the knife. Danny says he gave her the knife, right? There's inconsistencies either way you look at it with Marlene. But she does say that Danny initiated contact. And at the very least, Danny threw that case of pop, right?
Soda.
I have no doubt that Ms. Nicholson's about to talk to you about the fact that Mr. Clouse was drinking, right? And the state would, seemingly argue that no one who's been drinking can be the victim of a crime because he doesn't know what's going on, right? You saw the video. We heard the testimony from the officers. He's responsive to questions. He gives basically the same story on the video that he did here on the stand today. And there was maybe a little confusion over punching or hitting. It seems like Mr. Clouse was a little confused over exactly what was asked there. But, if you are being pushed backwards by your wrists hard enough that you have 2 small superficial stab wounds on your arm that need to be treated by EMTs, that surely could constitute as hitting to me. And you heard from Mr. Clouse, right? This is his Friday routine, right? He drank 2.5, 2.5, 20-ounce tumblers over the span of 18 hours or so. He didn't sleep because he wanted to spend time with his dogs.
It's just a typical Friday night. You get home, you stay up drinking, you have 2 huge tumblers of alcohol, and you play with your dogs, as one does. I don't know how you guys spend your weekend, but
Personally, I like sleep, but hey, to each their own, right? It's not illegal to stay up all night hanging out with your dogs. Again, we saw in the video, he's responsive. The deputy said he was responsive. And furthermore, I think the last thing that I want to hit on is the fact that in Danny's statement, he said that the door was closed and he needed to pull it open so that he could get out, right? Carl says he left the door open so the dogs can come and go, right? See everybody. Talking about a guy who got emotional just by the mere mention of his dogs because he misses them. Right? To me, that doesn't seem like someone who's going to lie about details with his dogs. What we do know is in these pictures, that back door is open. Right? Last thing I want to hit on. Right? Ms. Nicholson talked about, reasonable, putting yourselves in the shoes of the defendant. Right? Talking about a 64-year-old man who has been beat up by his son before. Right? He talked quite at length. He's an old man now, right? He's scared. He has a neck injury. He doesn't want to get hurt. He doesn't want to get his face beat in by his own words, right? All of this has happened before. There's a long history between these parties. We would argue that Carl Clouse's responses were reasonable in this situation to avoid himself getting hurt. Again, look at the details, look at the pictures, listen to the evidence, and think about what makes the most sense. No blood from about here up on Carl Clouse's shirt. If the incident happened as Danny outlined it, would have been blood everywhere. So ladies and gentlemen of the jury, we would argue that after you look at all the evidence and have the opportunity to deliberate, that you must find Carl Clouse not guilty of these charges. Thank you.
Thank you, Mr. Brenner. Ms. Nicholson?
Ladies and gentlemen, I want to start with the reasonable grounds to believe that the defendant was in imminent or immediate danger of death or great bodily harm. The defendant said he was so scared. His reason for that fear? One incident 10 years ago. An incident where Danny told you about, he was up front, he was convicted of disorderly conduct, and the defendant told you he was also arrested in the course of that incident. 10 years ago. I asked him specifically for other times, other examples where Danny has assaulted him, because he told Mr. Brenner that. And I said, tell me about those. He couldn't. He didn't describe any for you. All he came up with was a time where he said Danny would have out in front of their trailer. And I said, did he? And he said, no. I asked him specifically what was different about this time that he felt he needed to pull a weapon than any of the other times he described for Mr. Brenner that they had arguments or that Danny got upset with him. He never answered that question. He couldn't tell you what was different about this time. What was different about the second half of the argument versus the first half of the argument? All he said was Danny was yelling at him to shut his fucking mouth.
Language.
That's all he told you Danny did before he pulled a knife as Danny stood 30 feet away at his bedroom door. He already had the knife out. And all Danny was doing was yelling. They're the same size. Yeah, the defendant's 20 years older. But Danny's not a big guy. And the defendant had the weapon. And even after Danny is stabbed, even at the defendant's story, it magically poked him as it fell through the air. Danny doesn't attack the defendant. He's so aggressive and wants to beat his dad up so bad that after he gets poked with the knife his dad is holding, he doesn't attack the defendant.
What? So it's this awful felony 2 wound when it's convenient and it's awful. But then when it comes to how he responds after he's poked, he just calmly goes and sits for the police. I mean, which one is it? It's either a brutal wound that deserves years in prison, or he was just poked.
He just walks out of the house as soon as he's able to gain control of the knife. He tells you that he did what was necessary to get the defendant to drop the knife, and then he leaves the house. The defendant had some, in his own words, scratches on his arm. That's what he told EMTs. And he told Deputy Hale, I don't even know how I got them. Well, yesterday, they were from the knife. But within minutes of this incident occurring, they are scratches, and he doesn't know how they got there. He has no other injuries. So big, bad, scary Danny, who's just gonna beat the crap out of his dad all the time, after getting stabbed, doesn't do anything.
Because he was stabbed.
And the defendant wants you to believe that Danny's making all of this up to get him out of the house. Danny wants to take over the daddy role. That's what he told Deputy Hale. He seems to have a problem with Danny's lack of responsibilities, lack of employment, Sure, Danny should probably get on his own 2 feet. Doesn't need to be living at home when he's
He's
43.
a bum.
I don't think anybody disagrees with that. Danny probably doesn't disagree with that.
He's lazy.
But yet, according to the defendant, Danny wants him out of the house. And what's Danny going to have to do if he's out of the house? He has all the responsibility. He's got to help take care of mom. He's got to pay the bills. He's got to maintain the trailer. Seems like pretty ambitious things for the defendant's lazy son.
Okay, do you think he really is concerned with the third step? Step 1 is get father convicted. Step 2, steal the house. Step 3, get the house. I don't know if he's really focusing on how to do the upkeep, mow the grass. He isn't really thinking about that. I'm just saying it's possible that could be what he's trying to do.
And the defendant doesn't account for Marlene's testimony.
Step 4, profit.
She has issues. She admits that. What's in her brain doesn't come out the right way. But the defendant also told you she wouldn't lie for him. And she didn't. She told you she was in the kitchen.
She also said that.
She said she didn't see the knife in Carl's hand. She's stuck between a rock and a hard place. She's got her spouse of 43 years on one side and her son on the other. She's clearly not trying to pick a side. Mr. Brunner's right. She has inconsistencies that help or hurt both sides. But she said she was in the kitchen. She saw an argument. She tells you what Daniel said. She came in here and told the truth. The best that she could. Even when the defendant disagreed with her recollection. Well, you were in the bathroom. Yeah, at some point I was in the bathroom, but I was in the kitchen. And there was an argument. The defendant yesterday said, well, it wasn't even an argument. I wouldn't even call it an argument. And Daniel told you about all of the physical contact he made, willingly and voluntarily. He told you about things the defendant denies he did. The defendant says, he never threw pop at me. And if he did, I don't remember it. And if he did, he certainly didn't hit me with it. But Daniel said that happened. Daniel said, I had my hand at his neck, putting my thumb on a pressure point. Defendant said, absolutely, there's no way he did that. Why would somebody admit to that kind of conduct if they didn't do that? He told you what he did in response to the defendant's act of stabbing him. And the defendant's testimony. Evaluate it in the context of everything else you heard. And weigh it the same way you weigh everybody else's testimony. Use your common sense, ladies and gentlemen. Remember when we talked about reasonable doubt yesterday? To be honest, I don't understand the story of the falling knife enough to really coherently tell you why it doesn't make sense. It just doesn't. They're falling backwards. Danny's got his arms. The knife is up. They're falling backwards, and the blade somehow falls and lands on his stomach, not the floor, his stomach, and stays there until Danny's arm can hit it at a 45-degree angle in some portion of the laundry room. Now, Danny tells you he took Carl to the ground. Carl says, no, I tripped. And he accidentally got stuck. And then Daniel bled so profusely on the defendant's shirt in his stomach area, but did not get blood anywhere else on the defendant as he climbs over him, so concerned with the defendant's phone. Not the defendant, whose knife just stabbed him, but the defendant's phone for some unknown reason. It doesn't make any sense, ladies and gentlemen.
don't
None.
make sense.
And we've all heard the old adage, don't bring a gun to a knife fight. Well, the same principle applies to this case. Don't bring a knife to a word fight. Because when you do, you are responsible for what happens. The court's going to tell you words alone do not justify the use of deadly force. No matter how abusive the language, whether there were verbal threats, or how provocative the words are. And the defendant, in his own words to Deputy Hale, minutes after this incident, said, "Danny never threatened me." And Danny only made physical contact, admittedly by the defendant's own story, after the defendant pulled a knife. He brought a deadly weapon to a verbal argument. The defendant escalated. He brought a weapon and someone got hurt. That's on him. He can't have this both ways. I acted in self-defense, but I didn't actually do anything. Remember in voir dire, we talked about self-defense is a justification for your conduct. All he says he did is pull a knife when Danny is 30 feet away, telling him to shut his fucking mouth. That's it. That is not reasonable belief that you are in imminent danger of great bodily harm or death. And that does not allow you to use deadly force. Ladies and gentlemen, the state has proven the elements of felonious assault and domestic violence to you beyond a reasonable doubt. And we have proven that the defendant did not act in self-defense. He started it, he escalated it. He did not have a reasonable belief that he was in imminent danger, imminent, and he used unreasonable force. Therefore, we ask that you find the defendant guilty. Thank you.
Thank you, Ms. Nicholson. Members
My
of the
ears
jury,
want
you've heard the
everything.
evidence and the arguments of counsel. It is now my duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law or
we'll
to apply
just
your
a
own
little
idea
bit.
of what you think the law
Minute
is
or
or
two.
ought to be. Financial evidence are of equal weight,
To the
stricken by the court or that you were instructed to disregard. You must not speculate why an objection was sustained to any question that was not answered or what the answer to that question might have been, because these are questions of law and rest solely with the court. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the believability of the witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. The testimony of a law enforcement officer is to be weighed by the same rules that apply to other witnesses. You are to weigh the testimony of the defendant by the same rules that apply to other witnesses. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as when they were originally taken.
Got it already.
You, if any, the exhibit should receive in light of all the evidence. A videotape and testimony relating to it has been introduced into evidence. You shall consider whether the videotape is a true record of what transpired at the time it was taken. If you find that it was, You will then determine what weight, if any, the videotape recording should receive in light of all the evidence. Now, the defendant is charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about August 2nd, 2025, and in Warren County, Ohio, the defendant knowingly caused serious physical harm to another. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. The state charges that the act of the defendant caused serious physical harm to a person. Cause is an essential element of the offense. Cause is an act or failure to act in a natural and continuous sequence, directly produces the physical harm to a person and without which it would not have occurred. The defendant's responsibility is not limited to the immediate and most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable consequences and/or results that follow in the ordinary course of events from the act. Serious physical harm to persons means any of the following: any physical harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of intractable pain. If you find the state proved beyond a reasonable doubt all the essential elements of felonious assault, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault, then your verdict must be not guilty. The defendant is also charged with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about August 2nd, 2025, and in Warren County, Ohio, the defendant knowingly caused or attempted to cause physical harm to another by means of a deadly weapon. The court has previously defined knowingly, cause, natural consequence, and those definitions shall also apply here. Deadly weapon means any instrument, device, or thing capable of inflicting death and designed or specially adapted for use as a weapon or possessed, carried, or used as a weapon. Physical harm to persons means any injury, illness, or other physiological impairment regardless of its gravity or duration. A deadly weapon is an instrument, device, or thing that has two characteristics. The first characteristic is that it is capable of inflicting or causing death.
So it's deadly.
The second characteristic is in the alternative. Either the instrument, device, or thing was designed or specially adapted for use as a weapon, or it was possessed, carried, or used in this case as a weapon. These are questions of fact for you to decide. If you find the state proved beyond a reasonable doubt all the essential elements of felonious assault, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of felonious assault, then your verdict must be not guilty. Count 3, the defendant is charged with domestic violence. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about August 2nd, 2025, and in Warren County, Ohio, the defendant knowingly caused or attempted to cause physical harm to a family or household member. The court has previously defined knowingly, cause, natural consequences, and physical harm, and those definitions shall also apply here. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. Family or household member means a parent, a foster parent, or a child of the offender, or another person related by consanguinity or affinity to the offender. Family or household member includes the natural parent of any child of whom the offender is the other natural parent or is the putative other natural parent. If you find the state proved beyond a reasonable doubt all the essential elements of domestic violence, then your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of domestic violence, then your verdict must be not guilty. If your verdict is guilty on this count, you will separately decide whether the state proved beyond a reasonable doubt that the defendant has previously pleaded guilty to or been convicted of one offense of domestic violence or a violation of an existing or former municipal ordinance or law of this or any other state in the United States that is substantially similar to any of those sections if the victim of the violation was a family or household member at the time of the commission of the violation. The defendant is asserting an affirmative defense known as self-defense. A person is allowed to use deadly force in self-defense. The state must prove, beyond a reasonable doubt, that the defendant, when using deadly force, did not act in self-defense. To prove that the defendant's use of deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. A, the defendant was at fault in creating the situation giving rise to the event in which the use of deadly force occurred. B, the defendant did not have reasonable grounds to believe that he was in imminent, immediate danger of death or great bodily harm. Or C, the defendant did not have an honest belief, even if mistaken, that he was in imminent, immediate danger of death or great bodily harm. Or D, the defendant violated a duty to retreat to avoid danger. Or E, the defendant used unreasonable force. In deciding whether the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, you need not be unanimous as to which of the five were proven, as long as each juror has concluded that the state has proven beyond a reasonable doubt any one of the five listed above. The defendant did not have a duty to retreat if, number one, he retreated from the situation or reasonably indicated his intention to retreat from the situation and no longer participate in it. Number two, he then had reasonable grounds to believe and an honest belief that he was in imminent danger of death or great bodily harm. And three, the only reasonable means of escape from that danger was by the use of deadly force, even though he was mistaken as to the existence of that danger. Deadly force means any force that carries with it a substantial risk that it will proximately result in the death of a person. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation, incident, or argument that resulted in the injury. The defendant was at fault if the defendant was the initial aggressor, and A, the victim did not escalate the situation, incident, or argument by being the first to use or attempt to use deadly force. B, the defendant provoked the victim into using force. C, the defendant did not withdraw from the situation, incident, or argument. Or D, the defendant withdrew from the situation, incident, or argument, but did not inform the victim or reasonably indicate by words or act to the victim of his withdrawal. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in imminent and or immediate danger of death or great bodily harm, you must put yourself in the position of the defendant with his characteristics, his knowledge or lack of knowledge, and under the circumstances and conditions that surrounded him at the time. You must consider the conduct of the victim and decide whether his acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be killed or receive great bodily harm. The defendant had no duty to retreat before using deadly force in self-defense if the defendant was in a place in which he lawfully had a right to be. Words alone do not justify the use of force. Resort to such force is not justified by abusive language, verbal threats, or other words, no matter how provocative. If the defendant used more force than reasonably necessary, or if the force used is greatly disproportionate to the apparent danger, then the defense of self-defense is not available. If you find that the state proved beyond a reasonable doubt all the essential elements of the offenses of felonious assault, count 2 felonious assault, and or domestic violence, and the state proved beyond a reasonable doubt that self-defense does not apply, you must find the defendant guilty according to your findings. You must then circle the word guilty on the verdict form and sign your name in ink on the lines provided. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offenses of felonious assault, and domestic violence, or if you find the state failed to prove beyond a reasonable doubt that the self-defense does not.
All right, enough of that. I was kind of hoping to get it closer to 4, but oh well. We'll do the verdict next, talk for a minute, and then I'll redirect y'all over to Hella, who's going to start around 7 to 7:15. Okay. Yes, Junior? Come on. Yeah. Okay, so I think it's going to start soon. There we go. Everyone's coming in now. Oh, look at our boy. Look at Bubbles. What do you just go? Wash my hands of this. Okay, so wife and son are there. Prosecutor's just playing on Tinder. Defense attorney's hoping he wins his first trial.
All right.
All right. Justice for my boy Bubbles. Nah, they have a verdict, one way or the other. And
Thank you. Please
going
be
to
seated.
master my boy.
Mr. Harvey, you have the verdict forms. Are you the foreperson of the jury?
Yes, Your Honor.
Can you tell me, has the jury reached a verdict?
We have.
Could you hand the verdict forms to Mr. Loxton, please?
Well, they didn't. They did not allow the knife to go back with the jury, which probably was a smart move. One.
In the matter of the State of Ohio versus Carl Clouse, the verdict form as to count one reads as follows. We, the jury, being duly impaneled, sworn, or affirmed, find the defendant Carl Clouse guilty of felonious assault as he stands charged in the indictment. As to count two, we, the jury, being duly impaneled, sworn, or affirmed, find the defendant Carl Clouse guilty of felonious assault as he stands charged in the indictment.
My boy.
As to count three, we, the jury, being duly impaneled, sworn, or affirmed, find the defendant Carl Clouse guilty of felonious domestic violence as he stands charged in the indictment. The jury further finds that the state did prove beyond a reasonable doubt that the defendant previously pleaded to or was convicted of an offense of domestic violence. The additional finding is signed by all 12 members of the jury. Does the state wish to have the jury polled?
No, Your Honor.
Does the defense wish to have the
No,
jury
Your
polled?
Honor.
All right, very good. Ladies and gentlemen, that concludes your service as jurors in this case. You have the court's thanks.
I don't feel. Yeah, I feel probably on the merits he was guilty, but I really dislike the son, and the charges are really severe for what happened. But I do find it really interesting that chat is so divided on this. Even like some of you guys that normally kind of agree on everything are split. Which, that's fine. I think that's good to have difference of opinion. I just find it interesting. This case has been unique or unusual and has some of the ones I've covered. He gets 8 years. Yeah, he's gonna get like 2 to 8 per charge per felony, plus the domestic, which is a felony 4. Assuming it's consecutive. His priors weren't that severe. Nothing too major. I don't know. I probably would not want to be sentenced in front of Judge Teep. But oh, and the DV charge might merge too. Yeah. No, they're going to do sentencing. It'll be in a few weeks. They were violent felonies? I don't believe so. Let me just double check. Clouse. Oh, what the hell's his name? The only one I've no, that's a civil case. I'm not sure then. This is the only criminal one in Warren County. But oh, he is a felon. He did lose his gun rights. Because none of it made sense. None of the witnesses were clear on what happened. Yeah. He lost his gun rights. I know that. Because of where he wasn't able to have guns. Because of I don't know if it was because of a felony or the domestic issues he had in the past with his son. Which, quite frankly, yeah. Yeah, I mean, considering the hot blood between the two, it's probably good there's not a gun involved. Oh, this sucked, but, Ohio has no sentencing guidelines. It is completely up to Judge Teep. He's a tough judge, but does look at each case individually, and I've seen him give probation for a felony 2 before. Really, Connor? Okay, so they're like when it says like 2 to 8 years, that's not like a minimum of 2. Like I understand how they came to the verdict. I just feel like the charges don't really reflect the punishment or the charges don't really reflect the severity of what happened. Yeah, he's been in jail for 90 days. I imagine he'll be doing more time. I wonder if Pops has knocked around his old lady once or twice. Possible, but there was no evidence of that presented. Yeah, I know it's serious when a knife was involved, but like it was just his arm, and I don't know. I guess I'm biased because I really dislike the son. So, there was some talk that the son might be a pill fiend, but that all came from dad. So I don't know how true that is. Ohio has sentencing ranges, but not guidelines in the same sense as the feds. So the guidelines are what you have to do. I guess every jurisdiction is a different term for it. Yeah. Ohio needs to ban pointy tip knives. Yeah. Common sense knife control. That's a good point, Eric. Okay. I am going to send y'all over to Excited Utterance. She'll be starting in about 10 to 15 minutes. Maybe 20 or. We are going to be exploring more about the lovely hidden true crime Lauren. We got some body cam footage from CrimeCon where she claimed she was being stalked and was able to get her stalker kicked out of the bar so Lauren could, I guess, enjoy a drink. She's set for 9 minutes from now. Good. Okay. Ella didn't confirm with me if she changed it or not. So guidelines would say if you did X before this, you serve XX. If you did Y before this, you get YY. I see. Let me just make sure redirect's all set up. Yep. Awesome. All right, guys. Thanks for being here. Oh, I'm sorry, Ella. No, I'm not complaining. I'm not criticizing you. I know you're scrambling, and that's okay. Wasn't, thank you for working with me here. I don't know yet what the trial will be next. There may be one Thursday. I'm not sure yet. Probably not. Probably with another Warren County one. I'll look and see what I can find for at the very least we'll do another one next week. Okay. All right, guys. Thanks so much for being here. This was a lot of fun. Definitely educational. And what not to do if you have a shitty son, at the very least. But I'm going to end now. Send y'all over to Hella. Go Blue Jays. And I shall see you guys in a little bit. Godspeed.